Alright folks, so welcome to our latest video. Today we're going to be looking at our continued approach to the rights and freedoms within Canadian law, and we're looking at specifically the Oakes test. So hopefully by now you read the overview which I posted to the site, the OGen overview, which is a pretty good one. This is one of the first sort of major challenges to the Charter, and specifically we're looking at Section 1, the idea of reasonable limits of our Charter rights. And these are the questions that you guys were supposed to be looking at within the OGen document, so we'll just quickly go over some of these things and what we think about this. So again, the Oakes test is here to determine, after an infringement has been established, whether it's reasonable, whether it's unreasonable. That's the kind of thing. It's not specifically about if a right was infringed or not. It's about whether that's a reasonable and understandable infringement. That's an important thing to remember as we go forward here. So looking at Section 1 here, this first part that talks about the idea that how does it both guarantee and limit rights? Well, Section 1 of the Charter establishes that every single Canadian is guaranteed rights protected by the Charter. We already knew that, of course, but simultaneously it provides the possibility that these rights can be limited. So the government has the possibility and the capacity to limit your rights if the limit is demonstrated to be justified in a free and democratic society. So if there's a reason for limiting your freedom, they can do that. Right, so that's something to consider. So we look at programs like the MAD program, the drunk driving program, whereby people are stopped and then the officers do the spot checks on the road. That is infringing on your rights in some ways, but it's a reasonable and justifiable infringement because it is generally considered a safer and better protective system for everybody within society. So looking at question 2 here, you talked about the idea that why does the government have to justify limiting a person's rights? Well, that's fairly self-explanatory, I think. The Charter is in place to ensure that rights and freedoms of Canadians are protected, of course. So requiring the government to justify any Charter infringements ensures that these rights and freedoms are not arbitrarily limited by the government. So the government can't just do what it wants and infringe your rights whenever it wants. So the government has this burden of proof that they have to limit for their limits, they have to be justified. This is the significance of the Oakes case, the RV Oakes case, is that this is a Supreme Court ruling that establishes the Oakes test, which is the sort of shorthand way of looking at whether the infringement imposed by government is justifiable and not justifiable. So this question here is talking about this idea where infringement of rights would be justified. So you might have come up with different examples for this. Something would include anything like the safety and protection of people, of individuals, safety and protection of children. If you think to some of the cases where blood transfusions for Jehovah's Witnesses, there was a case in BC many years ago where parents of a child who needed a blood transfusion refused based on religious grounds, and there was a big discussion about who was doing what's best for the child. Is it safe and is it right to infringe upon the religious freedom and the rights of the parents to potentially save the life of this child? Conversely, we look at a situation where an infringement of a right would not be justified. This could be an example where the government is cracking down on peaceful assembly or censorship of media or anything like that. That would not be justifiable. For looking at this question here about the role of the court in determining whether an infringement of right can be justified, I think this is important because we have to maintain this idea and remember that there's a separation between the courts and the political system. We want to maintain this separation between the two because our political officials are elected and they're chosen to run the country and for whatever else. But our legal officials are not elected. These are people who are supposed to be impartial, nonpartisan, supporting just the law and interpreting the law as it should be. Right? So this is why we want to make sure we have some separation between the two because we don't want to politicize rights. That's not what we're doing. Right? We want to make sure that the judges who are the ones who apply the law. So in terms of remedies, then what happens if the government cannot show that a Charter infringement is justified? So if it doesn't pass the Oakes test. So the Oakes test is about whether the infringement itself is justified. If something does not pass the Oakes test, what can be done? We're going to look at some of the different remedies a little bit later on here, but there's a couple of different things that can happen. So if it doesn't satisfy the elements of the Section 1 analysis, we'll talk a bit about that. Okay, so there's a couple of different ways that you can go through this. So essentially, this is what Section 1 analysis looks like. This is a broken down version of the Oakes test, a simplified version. So if you were looking at a potential rights case or potential Charter challenge, you would just discuss the idea of whether the law is pressing and substantial. Right? Is the purpose of this law important enough? That's the first part. Is this important? Because ultimately that's what we want to see, right? So is the law's goal pressing and substantial? If it is, yes, then move on to the next one. Is the law rationally connected to its purpose? So if it's about protection for people for drunk driving and the law is about the use of strollers in the mall, that those things are not connected, right? So we want to make sure the purpose is connected to the law itself. It has to be rational. Does the law minimally impair the infringed right? So if you are found that the law or the change to the law has been infringing on your rights, the court wants to make sure that it's of minimal impairment. So if your rights are infringed, we want it to be as little as possible, and that makes sense, I think. Then we have to look at the positive outweighing the negative, and obviously if the infringement is more positive than negative, it could potentially be justified. Ultimately, if you're looking at all these different questions and the answer is yes, 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 we could say yes, the infringement is justified. So here's a potential case scenario for you. And I'll go through this one with you, and then I'll give you a couple ones after this that you can try out on your own. So in this one, and you can read the case, it's about breathalyzers at the school. Pause the video if you want to read it a little bit longer. But this is the idea that in prom, in terms of protection of the students, they're going to bring in a breathalyzer. Is this okay if this was a charter challenge? I mean, obviously this is not a charter case because it's not imposed by the government, but the same principle could apply here. So if we want to look at Section 1 analysis for this particular rule, we will say rule, not law, because obviously we're not talking about an actual law here, but we can apply the same rigorous standard for this for the Oakes test. We can say, well, with this particular idea, is this a pressing and substantial rule? We can say yes, it's for protection of students, it's preventing drunk driving, it's better for the community, it's safer for everybody, provides peace of mind, it lowers liability, whatever you want to come up with with that. And if we say yes to this and all those make sense, we can move on to the next one. If we say no, there's no reason for this. All the students are underage, so there's theoretically no reason that any of them would be drinking in any capacity. There's no history of drunkenness at the prom, so we would say no. If we believe that, then we determine that it's not a justifiable infringement. The Oakes test is done. If we say yes, we move on to the next one. So is the law rationally connected to its purpose? Well, yes, the use of breathalyzer is directly connected to the purpose of preventing drinking and driving. Obviously, right? If we were talking about something else and they were using a different mechanism, we'd have to make sure that those two things work together. Breathalyzers and drunk driving are pretty much working together. The next part we'd say, does the law minimally impair the infringed right? Well, we could say yes, breathalyzer test generally takes less than 60 seconds, anywhere from 5 to 45 seconds on average. But of course, if you have a larger group of people, you probably want more than one breathalyzer. You don't want slowing everybody down for several hours. But even if that's the case, is that a minimal impairment? Are you minimally inconvenienced and impaired in terms of your rights for the potential safety benefit? That's something we want to look at next. So if we say yes, this is of minimal impairment, we keep moving on. So we'd say, do the positive effects of the law outweigh the negative effects of the infringement? So with this, we might say, yeah, it's minimal imposition for potential safety of all. So a couple minutes of extra time getting into the venue to run the breathalyzer, or however they set that up, is worth it for the overall payoff. So if we say yes to all of these different questions, we would say yes, this passes the Oakes test, the infringement is justified. Ultimately, that's where we want to go. So that's the idea. However, if we're talking about an actual charter case, and we determine that it doesn't pass the Oakes test, it doesn't meet the standard for a justifiable infringement, there's a couple different options you could have if this was a real charter case, and there's a couple other ones you can look at online. You can find those. Some of the remedies available to the courts are things like striking down, partial invalidity, reading down, reading in, constitutional exemption, and temporary suspension of invalidity. We'll talk a bit about those. So with striking down, this is when the court can declare that the law infringes the charter and is nullified. So the law itself is of no force or of effect, so the law is basically done. For partial invalidity, this is more of an alternative that we see to striking down an entire law. We don't necessarily want to strike down the entire law, so we say, well, part of it is invalid. This is where we say, well, this particular section or this subsection of this law or this particular part of it needs to be reworded or taken out or removed or whatever it needs to be done. So this is how we save most of the law, but we change that little part that is determined to be an infringement of rights and an unjustifiable infringement of rights. For reading down, we look at this and say, well, this is where the court interprets the legislation in a sufficiently narrow way to bring it in line with the charter. So to give you an example, there was a case, R.V. Butler, and the Supreme Court read down the extremely broad terms of the obscenity laws that were in challenge in the criminal code in order to avoid any infringement of freedom of expression. So the court held that provisions should be interpreted very, very narrowly to catch only certain forms of what was deemed to be obscene pornography, and that's what this particular case is about. So they very specifically determined what was that going to look like and what was that going to be. For reading in, we would look at this as a technique that's used when the statute is somewhat under-inclusive and fails to extend to those who have legitimate constitutional claim to its protection. So in this case, the court may read in these categories of individuals rather than strike down the law entirely. So to give you an example, this approach was taken in a case in Alberta when sexual orientation was read into human rights legislation in Alberta. So reading in is something of a controversial remedy, as the court appears to be taking on more of a legislative role. So it's more like the court is actually making law here. They're changing and adding things to the law, which is not necessarily the purpose of the court. But this is a remedy that is available to them and within their jurisdiction and within their purview as the courts. They can do this kind of thing. But we would say, even though it might be somewhat challenging, it's usually more suitable alternative to completely striking down the legislation as a whole, because again, legislation takes time. And if we're adding things and changing things and people are okay with this and we're approving it, that's not necessarily a problem. In constitutional exemption, the court may order that a particular law is valid, but a certain individual is exempt from its application. So this is fairly rare. I can't even think of an example of this, but I could see if I can find one for you guys. But it's a fairly rare instance where somebody on particular circumstance would be exempt from this constitutional part. And the last one, we look at temporary suspension of invalidity. So a court can declare that a statute or provision within it is invalid, but allows the law to remain in force for a certain period of time to allow Parliament or legislature to change the law. So this is basically an alternative to striking down, because we'd say, well, part of it is invalid, you have to make some changes, but the rest of it will stay in effect, or it will stay in effect until the new law comes into place. And that's, again, creates a somewhat tricky area, but the courts balance this against the two sides. So these are some of the options that are available to you if you find that a charter case in terms of infringement of rights has been brought by the government, and what happens if they, using applying the Oakes test, the courts decide that yes, the infringement has happened and is not justifiable. So important things to remember here in terms of the Oakes test. This is about justifiable infringement. It's not determining if the infringement has taken place. This is a mistake a lot of people make. They'd say, well, yes, this particular law, this particular legislation violates this person's rights due to section whatever in the charter. That's not the point. The point of the Oakes test is determining, yes, we already know the infringement has happened. Is this okay? Is it justifiable? Is it minimal? Is it proportional? Right? So this is all within section 1, the reasonable limits part of the charter. The charter expressly says this. Your rights are limited to what is reasonable in a democratic society. So this is about what's important and what's proportional. Is the infringement important enough to happen? Is it proportional to what it's supposed to do? That's what you really need to remember in terms of application of the Oakes test. So with that, I would say use the simplified, modified Oakes test that I'll provide for you guys on the site, and actually practice this a couple times. So maybe take one of these following two cases, so pick whichever one you want. I'll move to the next slide in just a moment here, but you can pause the video whenever you need to. But one of those two will give you some information, and that's what you want to take a look at in terms of applying the Oakes test. You can do both if you want to, but I would try with at least one of them just to get some idea of determining whether or not the infringement here. So obviously with these ones we're not talking about charter cases, but we would use the same principle and concept. So just use that idea and apply the Oakes test to these particular cases and see if it works, see if it makes sense, see if you can justify and rationalize this. Take this from the perspective of both the defense and the Crown if you want, because there will be different interpretation depending on how it's presented. There is no clear-cut answer. If it was that easy, there wouldn't be charter cases like this. You have to be able to argue and represent both sides. So maybe take one of these, look at it from both perspectives. How would you view this? How would you counteract any particular part of the Oakes test that says, well, yes, the infringement is justified. Well, how might it not be justified? Right? So this is something you would potentially argue in front of the Supreme Court. So keep that in mind as you're going through. Practice these two. Take a look at the modified test. As I said, I post it to our site, and see what you can do with this. Okay? Have fun.